Montgomery County Tea Party, and we're here with Scott Goleman, and he's running for the Court of Appeals, District 9. It's Wednesday, December 18th, 2019. With me is Larry Rogers, Bob Bagley, and David Smith. So Scott, as we talked about, well, first of all, thanks for coming in. And as we just discussed, if you want to get us started off and take up 5 minutes for an opening, and then we'll go around the table for the next 45 minutes in the Q&A session.
Okay. Well, first off, I want to thank all of y'all very much for allowing me the opportunity to go through this vetting process with the Montgomery County Republican Party, Tea Party. And thank y'all for what y'all do in this opportunity. For those of you that don't know me, my name is Scott Goleman. I'm a civil trial attorney. I've been practicing in Montgomery County for the last 31 years. And I'm here today running for Chief Justice of the 9th District Court of Appeals. And you might ask why I'm running for this bench. And I would say my desire to run for an appellate bench has occurred more so in the last 6 years of my practice. I started back July of '88 when I was passed the bar exam. I started with Reuben Hope and Associates here in Conroe, doing predominantly civil defense work. And in that capacity, I started trying a lot of cases, not just in Montgomery County, but all in Houston, and then along the Texas-Louisiana border, the counties east of here. Back at that point in time, the courts in Harris County were typically Republican, were particularly conservative, as well as a lot of the counties east of Montgomery County that I tried cases in. However, back in July of '88 and in the late '80s, early '90s, Beaumont Court of Appeals, which is the 9th District Court of Appeals, was probably the most liberal Court of Appeals in the state of Texas. All the cases from Montgomery County are appealed to the Beaumont Court of Appeals, and that was what we were faced with. And I've continued my civil practice for the last 31 years. I believe conservatively, I probably have at least 300 jury trials under my belt. Less bench trials, because almost everything I do is in front of a jury. Probably about 30 bench trials. But in the last 6 years, I've worked for Hope and Causey, which used to be the old law offices of Reuben Hope firm. And it is based here in Montgomery County. However, we have offices in Houston, we have offices in San Antonio and Kennedy. And literally I've tried cases over most of the state of Texas, as well as handled appeals through most of the appeal courts over the state of Texas. We have 14 Court of Appeals. I think I've probably handled appeals in 8 to 10 of those. But I've tried a lot of cases in Harris County. I've tried a lot of cases in San Antonio, Victoria, places of that nature. I've tried cases down in the valley, which is very liberal. I've tried cases predominantly I-35, San Antonio, Austin, on up, and everything east of that. And what I've found in the last 6 years, or I've been exposed to extremely liberal trial judges. And most of the big cities nowadays are controlled by Democrats, and therefore have elected very liberal trial judges. And what I've seen, not only from trial judges, but also from justices and Court of Appeals in those areas, is laws are ignored, blatantly ignored. Laws are watered down, where judges are actually creating law, legislating from the bench, which is very disheartening and difficult for a trial attorney that wants to make sure justice is done. And I've seen trial judges and Court of Appeals judges totally ignore Texas Supreme Court precedent. And that's one reason that, or the main reason that I've decided to run for this position. I will say in the last 20 years that the Beaumont Court of Appeals has been the most conservative Court of Appeals in the state of Texas, and I want to continue that. I will ensure to you that I will follow the law and enforce the law. I will not legislate from the bench, and I will uphold our laws so that everybody has free access and receives justice in the trial courts and in the Court of Appeals for the 10 counties that it controls. I've got, like I said, probably 300 trials. I've got 4 opponents in this race. I have nothing bad to say about any of the 4. But if you do research and check, you'll find out that my 4 opponents combined do not come anywhere near close to 300 trials. And this is a court that you have to have extensive trial experience in order to be qualified to be justice of this court. And I appreciate your support, and I appreciate your vote, and spread the word for Scott Goleman for Chief Justice of the 9th District Court of Appeals. Thank you. Bye.
All right, thank you. Appreciate it, Scott.
I got down to the last second.
Well timed, well rehearsed. So you mentioned that you've been a civil trial attorney for 31 plus years, handling cases all over the state of Texas. How much of that civil experience is family and probate, regular civil, and then how much is criminal experience?
Very little criminal experience. I actually had no criminal trials. Some of the civil cases I deal with have criminal components to it. Some of the civil cases I've dealt with have family law or probate components to them. But most of my trial work has been across the board civil litigation, whether it's representing individuals, businesses. I do plaintiff and defense work. Hope and Causey does a lot of insurance defense work for State Farm, Allstate, and in the past for USAA. And that's the majority of my practice in the last 6 years. I will say this, doctors practice medicine. You never get it down 100%. It's constantly, things are changing, new technologies in the medical profession, so it's the practice of medicine. Being an attorney, whether it's a litigation attorney or a transactional attorney, is the same thing. It is the practice of law. Laws are constantly changing due to the legislature, and you have to keep up with those changes. Of the 4 sitting justices right now on the 9th District Court of Appeals, 2 of them have had absolutely no criminal trial experience. The 3rd has handled some criminal cases but has never tried any criminal cases, and only Chief Justice McKeithen, as the former county attorney for Montgomery County, handled a very few criminal cases. We are all capable with our education and our training to be able to research and understand the law and apply the law and enforce the law.
Where in the county do you live?
I live in Cut and Shoot, Texas.
Cut and Shoot. Okay.
I've got 30 acres out there where I've raised 4 boys, along with my wonderful wife.
All right, next question. So, obviously, if you become the judge, you'll have to travel to Beaumont. Will that be a problem? And you'll have to get out of your law practice?
Well, obviously, if I'm elected, which I plan to be, as Chief Justice of the 9th District Court of Appeals, you don't practice law anymore, I would leave hope and causing, that's mandatory. I'll say this, Justice Charles Krager has a garage apartment over in Beaumont. Judge Steve McKeithen has an apartment over in Beaumont. And they typically leave early Monday mornings, drive to Beaumont, stay there in their apartments, and then they'll usually return to Montgomery County typically Thursday night or Friday, depending on the caseload. Judge McKeithen, the Chief Justice, does have an office here in Conroe in the administration building, or the annex, trying to remember, the building just west of the main entrance of the courthouse. That's what I'll do also. Beaumont Court of Appeals also does oral arguments here in Conroe in the old commissioner's courtroom to accommodate attorneys that are more from this area versus over in the eastern counties. Talking with the justices over in Beaumont, there was some discussion of the legislature moving the court over to Conroe, but it may be too cost prohibitive.
Okay.
So what we're talking about working, we've had a number of issues over the years with judges, not in the ninth, and we don't get to see them, so we don't know what's going on, but not showing up for work, their offices not being open, they're not being on the bench throughout the week. Mondays they're not at work, Fridays they're not at work. There's a different dynamic with your court where a lot of the stuff can be done from home or done from the office, so you don't actually have to be in the courtroom. How many employees will you have, or what staff-wise, and are you going to be working a full 40-hour week if elected?
Well, the answer to the very last portion of your question, probably not. And the reason is right now I'm working a minimum of 55 hours a week. When I'm in trial, that may get closer to 75 or 80 hours a week. I have no intention of working any less. I know one of y'all's questions raised that issue, how much are we going to be at work? I know the 4 justices over there very, very well. I've known them for decades, some of them, and I know the type of hours they put in. As far as employees, the Court of Appeals is sort of a unique situation. It's on the 2nd floor of the newer portion of the courthouse over there and takes up an entire, what I would say, the east side of that courthouse. You have the Court of Appeals clerk who has a couple of staff with her, where all the appeals come in, everything that's filed through her. You have a bailiff that, allows entrance back into the Court of Appeals offices. Each justice has 2 briefing attorneys, and each justice has at least 1 or 2 staff members. And then there is an older, more experienced lady that's sort of the chief of all the staff, knows everything and can get things done, but every justice has staff and 2 briefing attorneys. I've been over there several times. I've met all of these people. Right now, nobody is intending on retiring, with the exception of Chief Justice Steve McKeithen.
So essentially you'll have between 3 and 4 that are actually working for you. The others are working for the entire.
Yeah, all the justices
courthouse.
have similar sized staff, and all of them have 2 briefing attorneys.
Okay.
And every case over there is assigned to 3 justices. One of them will actually author the opinion, but those 3 justices will be signing off and agreeing on that opinion. The 4th justice is also included in the initial discussions of that opinion, so that he or she can agree or whatever. It's a compilation of at least 3 justices on every case But one of them would be responsible for actually writing the opinion.
Okay, thank you.
Okay, I have a series of informational questions based on your answer to the efficiency question, and I understand your answer. But what it did is it revealed my lack of understanding of the appeals court. So I guess I have a little bit better grasp on the high-level courts, the nation and the state. Does the appeals court pick and choose which cases it will hear on appeal, or does it take in every case that is appealed by a lower court?
Every case that's appealed by a lower court, whether it's from county court of law or district court, there is no option. So there'll be criminal, family, and civil cases.
Okay.
And then once that decision is made, which either upholds the trial court's judgment, if they think that everything was done properly and the law was followed, that opinion will be written, citing case law to that effect. Or if they disagree with what happened below, they can reverse the trial court's decision and send it back for a new trial. Or in certain situations, they can reverse and remand and actually change the judgment to be in accordance with the law.
So effectively then, there's little to no backlog as we find with district courts?
No, the job's got to get done. And the way the court is set up and the way the appeals are handled, all those cases are judiciously and efficiently moved on a timely matter, which is one reason for the 2 briefing attorneys. But you've got to understand, whichever side is not happy with the lower court decision appeals the case, they're the appellant. The other side is the appellee. They both have briefs, written briefs, where they're citing all the case law and making their argument, and that's a starting point for the judges and those briefing attorneys to start formulate what the law is and whether justice was done below or error was done below and what needs to be done, and then writing the opinion with the appropriate case law to substantiate that.
Okay.
And then whatever side does not agree with that decision can civilly appeal to the Texas Supreme Court, which they don't grant petition on a lot of the cases. Criminal goes to the Court of Criminal Appeals.
Okay.
Can
Thank
I tag on to that? So it was my understanding that this court can pick and choose pretty much what they want to hear.
Absolutely not. Not at the intermediate court level. Every appeal is handled by that court. Only the Texas Supreme Court and Court of Criminal Appeals can decide whether they're going to review a case from a court of appeal or not. And I can't tell you the percentages, but less than half the cases that are appealed are accepted by the Texas Supreme Court or the Court of Criminal Appeals.
Okay, thanks.
Recently, Montgomery County had a visiting judge overturn the Texas Open Meetings Act. And then, not long before that, Governor Perry, got convicted, for using his veto. And that was a visiting judge, and that was subsequently over-appealed. Are these visiting judges program being used by the local judges to hand off difficult cases, even though, denying the people of Texas the right to, choose their own judges? Is that being abused?
I can only speak for Montgomery County because I handle a lot of cases in Montgomery County, and I'm very familiar with those judges. Now, with that being said, doing civil litigation, that means that I'm dealing with Judge Claudia Laird, County Court of Law Number 2. I'm dealing with Kristen Bays, the 284th District Court, and I'm dealing with Jennifer Robin, the 410th District Court, because those are the only civil courts we have in Montgomery County, which is a major problem. But even the prior judges that have been more general jurisdiction, going back to my late 80s practice on up into the 90s and 2000, I can't say I've ever seen one of our Montgomery County judges pass off cases to visiting judges because they didn't want to handle them unless there was a reason that they needed to recuse themselves. In other words, there was a conflict of interest or a potential conflict of interest with that judge and any of the attorneys or parties, the litigants, which would require a visiting judge to make that decision. Most of what I've seen in Montgomery County where visiting judges are brought in, a lot of times has been to have 2 trials going on instead of 1. We've got an overflow courtroom in Montgomery County, which is utilized a whole lot by the civil court judges. So I saw Suzanne Stovall years ago use a visiting judge where there were 2 trials going on. I see the same thing with Kristen Bays now. You know, bringing in a visiting judge, and all this has to be approved and within budget, but bringing in judges so that we can do 2 trials at the same time to move the backlog along. I do want to make a comment though, because I mean, I know very little about those particular cases other than just in a broad sense. Whether it's a sitting judge or a visiting judge, the most important thing is judicial restraint and not legislating from the bench. And like I said, that's one of the major reasons that I'm running what I've seen in the larger metropolitan areas such as Harris County, Austin, San Antonio, with regard to judges that they've never tried a case, have no trial experience, or have got to the point where instead of following the law, they are being led by certain attorneys or just legislating from the bench and throwing it up there to see what happens on appeal.
Perfect segue into my question here. Under the question where we asked you among the 9 justices on SCOTUS, which one did you like and dislike? You had mentioned the Supreme Court's justices' judicial philosophy should be one of judicial restraint, what you just referred to. Rulings should be made based upon well-established tried and true case law precedents. A justice should exercise constitutional avoidance, where he or she refuses to rule on constitutional issues. My question is, shouldn't the justice rule with an eye towards both constitutions, the U.S. and the Texas, rather than avoiding it and instead of constitutional avoidance? Maybe I'm not understanding the terminology in your answer.
Yeah, and let me approach it from more of a attorney-judge standpoint.
Yeah, because if something comes up and a trial judge did something, ruled on something that's unconstitutional, the way he ruled on it, certainly y'all would address that. So anyway, go ahead.
Okay, and there's 2 aspects to that answer or that question. You have trial judges and trial attorneys, and then you've got appellate judges, and you've got state courts, and you've got federal courts. Number one, I can't tell you how many tens of thousands of cases I've handled in 31 years of practice. I can't tell you, I couldn't count on one hand the number of cases I've handled that involved a constitutional issue. Out of 300 trials, which is a conservative number, I can't tell you of one case that comes to memory where a constitutional issue was present or a major factor in that particular case and in that particular trial. I know the 4 justices on the 9th District Court of Appeals very well. I talk to them quite often. And when I've got that question, I specifically contacted some of them and talked to them and said, do y'all get that many cases on appeal that involve a constitutional issue? And the answer was rarely, and they had a hard time remembering times that they would have it. So, you're gonna get constitutional issues and constitutional questions more so in federal courts and in federal appeals processes. Because so much of the time, in order to have standing to bring a case in federal court, a lot of times it has to involve constitutional issues. You don't have that in state court. And real quick, in trying to explain my answer, unless a constitution is ambiguous, and this sort of goes back to your deal, which it wasn't, if it's not ambiguous, there's clear reading and understanding of what it says. There's clear precedent of interpreting that. You have a legislative history. You can go back to see what the legislature, because they debate all this stuff, and there's amendments and stuff like that to these constitutional issues and amendments. You have that to see what the intent was of the legislature, and whether something's ambiguous or not. And if it's not ambiguous, it doesn't need to be changed. We don't need to create new laws, and judges don't need to be creating laws to begin with. So if there's non-constitutional bases to make a decision, instead of relying upon a constitutional issue, you need to make it on those non-constitutional issues. And there's a lot of Court of Appeals, case law precedent, and a lot of Supreme Court precedent that you can rely on, where you never have to go over into the constitutional realm, which should be left up to the legislature.
Okay. Have you handled any cases in federal courts?
Yes. Matter of fact, the strange thing about it, and I did this on a recent questionnaire, my longest trial was 6 weeks long in front of Lee Rosenthal in the U.S. District Court in Houston, and my opponent was Chief Justice Steve McKeithen. It may have been the very last case he tried as Montgomery County attorney. And I've handled several cases, a lot of cases in federal court, but that one just comes to mind because it was very, very unique, and it was 6 weeks long, and it was against Steve McKeithen.
Who won?
Montgomery County won, okay? Justice was done. That was one of those deals that at the time I was working for Michael Mays, and 2 weeks before trial, I was brought into the office and told, you're gonna go try this case. So I had 2 weeks to prepare for a 6 week long trial.
Wow. Mark?
Okay, the ninth district, do you have any idea, percentage-wise, approximately, the breakdown between civil versus criminal?
It's more civil than criminal. At times it can be fairly close to 50-50, but it typically is more civil than criminal. And the civil cases, a lot of times, are extremely more complex and in-depth than the criminal cases. There's a lot of similarity between the rules of civil evidence and the rules of criminal evidence, and the Texas rules. Almost identical in a lot of ways. There's some difference between the rules of criminal procedure and the rules of civil procedure, mainly because there's a whole lot more civil procedural rules, because you have cases that involve a whole lot more pretrial matters, pretrial discovery, and can get very, very detailed and complex that can take a whole lot longer than a typical civil trial. That case I was talking about in federal court, it did involve constitutional issues. It did involve federal statutes. It wasn't criminal, it was civil, but the civil cases last longer and the appeals last longer because they're usually so much more in-depth and complex.
Okay. Bob?
We have an ongoing problem in in the state, in the nation, and even here in Montgomery County with civil asset forfeitures. I know you talked about it a little bit, but can you go on camera and explain your thoughts about civil asset forfeitures and due process?
Well, let me say this. First off, I've not been involved in civil asset forfeitures because that comes from the criminal side. Civil asset forfeitures are involving law enforcement in the district attorney's office and whatever court is handling that particular matter. The problem is there's not enough transparency, there's not enough oversight with regard to that, and we all know situations where innocent people have had their property wrongfully taken. There's another question that I answered about, indigent defense and things of that nature. Folks, most people do not have the wherewithal to pay an attorney on an hourly basis. So there is situations where legal assistance is needed, and there's situations where you have innocent people who have had their property wrongfully taken through forfeiture that need assistance. I don't know the solution to that problem. I think in my answer I said maybe Commissioner's Court, and that may not be the right avenue, but something needs to be done where there's the appropriate people impaneled to oversee these forfeiture procedures, and also how that forfeiture money is applied, because there's not enough oversight. The judges are stressed and limited on what they can do and time they can devote. So some group, and I don't know who sets that up, I would assume there'd be law enforcement on it, there needs to be attorneys on it, there needs to be citizens on it, citizens that have knowledge of these things, to look at these cases on a case-by-case basis and make sure that the forfeiture was appropriate, proper, that there was no wrongful taking. If there was, to get that turned around, and assistance needed to do that. And that's going to require the judicial involvement once that decision is made, and also that would include whether those funds are used appropriately. You don't buy trips or fancy things for the office and things of that nature with civil forfeited funds.
Do you think that it's appropriate to keep the assets, for the government to keep the assets when there's been no conviction?
Again, it's got to be on a case-by-case basis, and that's a very general and vague, overbroad question.
I don't think so. If you weren't guilty, why would you have your stuff? Why would they keep your stuff?
Well, that's a perfect point. I mean, if you're not convicted of something, why seize the property? And if you seize the property, why dispose of it, sell it to receive the funds, and then use the funds for whoever is in authority deems appropriate? That's exactly why I said some kind of oversight body needs to be set up to prevent this from happening and to take the appropriate recourse if it has occurred.
Okay, thank you.
Took my question. So I'll go back to another question that I have. You mentioned briefly indigent defense, and I guess I understand your answer. I agree with your answer, but it still didn't answer the question that we asked, which is what amount of indigent defense is appropriate? That which really gets back to a budget type question. And I don't know, is that budget set by the Commissioner's Court in each county? How do they set that? Is everybody entitled to one? I mean, I could read your answer and almost infer that you believe everybody is entitled to indigent defense.
Oh, absolutely not.
So what is the determination criteria? Do you know what that is? What should it be?
Well, it's going to be different between general civil versus family versus criminal. Every criminal is entitled to representation, a speedy trial, you know, a jury trial, right to a jury. The court asked, and I've sat in, you know, I've been in hearings where those types of matters have come up. The court inquires and the court questions the defendant about their income, their assets, their, you know, if they have family, friends, banks, things of that nature, you know, to go to hire an attorney. And the judge does a proper job of making those type of inquiries to see if that person should be providing defense at their own cost, or if they're truly indigent where the county needs to provide them with a defense. And in those situations, there's already a process and procedures set up where there are certain attorneys that the court does appoint to represent, and I'm talking more so in the criminal realm right now, that indigent defendant, and they're paid a much reduced pay scale versus if you went out and hired an attorney outright. But it's a I'm not going to say a flat fee, but it's specific fees that are approved that that attorney can recover or petition the court to be reimbursed for. But that system's already set up in the criminal aspect of cases, family law. What you see more in family law and in civil cases is if somebody comes to court pro se, the judge goes out of their way to talk to them and question them and get them to understand that even though they're pro se, they're going to be bound at trial by the rules of evidence and rules of procedure. So courts bend over backwards to grant continuances or reset hearings to allow that person time to go find an attorney to represent them. In the larger cities like the Houston Bar Association, you have those organizations that have banks of attorneys that do pro bono work. State Bar College, the Texas Supreme Court encourages every attorney to do some aspect of pro bono work. Even Montgomery County has capability of being provided pro bono expense. Family law matters, they can go to the Montgomery County Law Library and get assistance from the library staff on forms where they can handle the divorce, a simple divorce pro se. Can get them the right paperwork, the right forms, assist them on how they need to be filled out so that they can go back to the judge and present that and handle the case for them pro se. So not everybody's entitled to, you know, indigent defense. It's going to be based on the type of case and their particular condition and what resources the county has available to provide those. And Montgomery County does have pro bono assistance through the Montgomery County Bar Association and through the law library.
So the judge makes that determination. Who determines the budget?
From the criminal standpoint, that would be the Board of Judges. They come up with the range of what amount of fees will be paid for like a criminal defense attorney.
But do they tell the commissioner's court it's got to come out of county budget, or how does that work?
I do not know the answer to that.
Okay.
That's going to be handled between either the individual court's budget or whatever's set up with the Board of Judges and Commissioner's Court.
Okay, David.
Got about 10 minutes.
Our district attorney, several months ago, stood up in front of the Commissioner's Court and talked about the explosion of felony filings in Montgomery County, up 50–60% over the last 5 years. Recently, the courts ran out of money for public defenders, so we seem to have a crime wave sweeping the county. What's going on? What role does the judges play in that? And your thoughts on it?
Well, the judges don't play any role in the increase of crime in Montgomery County. You know, we're sitting here in the Woodlands where you'd think there'd be less crime, but some of the higher crime rates occur in the Woodlands, and it's just based on population. And also, we've got a DA, and again, I don't do criminal law, but I do follow things. We've got a DA that is extremely active. We all know about the DWI steps that were taken by the Montgomery County DA's office, the no refusal laws, the blood draw laws that have been created and are enforced. And even with that, there's still a massive amount of DWI arrests in Montgomery County. Nobody thinks it's going to happen to them, and nobody thinks they're going to be at the wrong place at the wrong time. But that's an issue. The other thing that the DA's office has done that you may or may not be knowledgeable of is Montgomery County is leading the state in cyber investigations and prosecution, and also in cyber child pornography and child molestation. They've taken some steps to really seek out and prosecute these cyber criminals, especially with regard to minor children, that is not done in some counties in the state of Texas. And Montgomery County is looked to as a leading example of what's needed in law enforcement, what's needed in the assistant DAs that are pushing this. And all of this has been created by our Montgomery County DA's office, and it's recognized across the state. So when you have an active DA that's really pushing this stuff and really pushing these prosecutions, that's going to result in more arrests and more cases too. So one feeds the other, unfortunately.
In our questionnaire, one of the questions was, do you think judges should be elected by the people or appointed by commission? Could you elaborate on your statement and your answer, because I didn't really get a good feeling on which way.
I think my race is the perfect example of that. Politics are different from judicial elections. Judicial elections shouldn't be based on popularity contest. Judicial elections shouldn't be based on who's the sweetest, best looking, best speaker, anything like that. It should be based upon who is the most qualified for the position. Now,
Can I stop you there?
yeah.
Why just judicial? Why not every elected position?
Well,
So it's okay to just vote for somebody?
don't get me wrong. I'm not saying that it should be any different from politicians, but I look at it from the standpoint that I'm not running or have not run for any political office. I have run for judicial office before. And
But that is a political office.
only from the standpoint that the voting public elects the politicians and elects the judges. But folks, this is a prime example of how important a justice is, whether it's for the 9th District Court of Appeals or whether it's for any court of appeals in the state of Texas. You can't just get elected with little or no trial experience and be a justice on a court of appeals. It's not something you can read and learn about in a book, whether it's a textbook or a law book. It's not something that you can go and get on-the-job experience and training for. I mean, I've talked to Chief Justice of another court of appeals west of here, who is an experienced trial attorney. And due to the change in demographics in large cities, has had a wave of Democratic justices elected to the Court of Appeals that have never tried a case. And he's had to slow down what's going on with the Court of Appeals and how they handle cases, because he's having to train these judges because they don't have a clue about trial work. A justice is grading the papers of the lower court, whether it's county court at law or it's district court. They know the law, they know the rules of evidence, they know the rules of procedure, they know how all of them intertwine and intermesh in the trial of a case. And that's something you can't pick up if you've never done it before. Only extensive judicial experience is going to teach you all that. It's going to teach you about the importance of the pretrial documents. It's going to teach you the importance of the exhibits and testimony that are admitted into evidence and whether that was done properly. It's going to teach you whether the appropriate laws were applied in the trial court that ended up getting the correct jury charge for the jury to determine. And it's going to teach you of whether the judge applied the appropriate law, whether the judge applied or allowed in the appropriate evidence and followed the appropriate law and procedure so that the right decision was made. And that's something you can't learn after the fact. Only extensive trial experience can teach you that. And my 300 plus jury trials over 31 years makes me the only candidate qualified for this position. You can get a judge elected that's never tried a case, and I've tried many a one in Harris County and in San Antonio, and it is a train wreck. They don't know what law to apply, they don't know how to apply the rules of evidence, they don't know how to apply the rules of civil procedure, and the worst of it hasn't hit us yet. Now, Dallas started 3 election cycles ago replacing all the Republican conservative judges, where there's just Democratic judges in Dallas. The last 2 election cycles in Harris County has resulted in this. And the ones that are in there trying the cases see how much of a train wreck it is and how much injustice is done. It's not so much from the attorneys as it is from the judges. Now, an attorney, if he's given an inch, he'll take a mile. And if he's got a liberal judge that's not willing to follow the law, he'll go right along with it. But and the end result is justice wasn't done, which makes the decision that much harder on the Court of Appeals and backslog the system even more when you're having to reverse or remand these cases back to the trial court for new trials. And when you got judges that don't have any trial experience, sending it back for a new trial may end up with another bad decision second go around. So it is a crisis that is increasing week by week, month by month in the state of Texas. And that's one of the main reasons why I'm running.
Well, I think that one of the great things about it is that that's one of the things we do in our vetting process. We give you the opportunity to give us your experience, and even though it's an elected position, we have the facts from all candidates. We post it on US Booksmart, and people can make their own decision.
And I went off on sort of a tangent. Can I have a little bit more time to sort of answer your question more? Because I said in my answer, I started off my answer, there's pros and cons. You could have commissions set up that, of judges, of attorneys, that would be better suited to research and determine the qualifications of a judicial candidate. But the problem is whatever party's in control is going to be selecting that situation. So the negative side is, if you got a commission that's democratically controlled, get ready. You're going to have liberal judges. If you have a conservative commission that's in control, thank God you might have more conservative judges. But throw another thorn in the deal is if you allowing these commissions to come out of the big cities and the big law firms, you're probably gonna get more liberal candidates. So, you know, the public may not know what to research or how to research to determine who's the most qualified candidate and who really should be elected, and they may do it on more on a popularity contest, but it's still the will of the people. And I'd rather have the will of the people than Democrats deciding to impeach Trump in the House and Republicans deciding not to convict him in the Senate.
That's probably what's gonna happen, Dale. Last question.
I've never been a complainant or a defendant, never had to hire a lawyer, never had to have indigent defense.
You're lucky.
But unfortunately, I've had a chance to observe some cases. And one of the things that it appears to me is that there's kind of a country club atmosphere within a county establishment, where if you have one of the lawyers who's from outside the county, then things tend to go toward things, because there's a country club between the lawyer who is in the county and the judge and any other witnesses, etc. Please comment on your experiences of that. You say you have litigated in many counties. I'm sure you've encountered or seen some of those one way or another. So would you please comment on how frequent that is? Is that a very real problem? And what would you suggest as any solution?
Yeah, it's a very real problem. It's called being hometown. You know, I grew up in the country, farming and ranching. I don't own any dress shoes, I own dress boots. And when I started with Reuben Hope and Associates, and y'all can tell I've got a Texas drawl, Reuben sent me over to Jefferson, Orange, Jasper, Newton, you know, Center, Texas, Hemphill, Texas, you know, Lufkin, Nacogdoches, and all this stuff. And yeah, there was times I've got hometown. You get hometown more when you're a baby attorney, trying cases. When you get to be an experienced, seasoned trial attorney and you're really good at it, you can overcome a lot of that. And the most important thing is, and I do this on every jury at every closing argument, it's instruction number 3 on every jury charge. You are the sole judges of the facts and the credibility of the witnesses and the weight to be given their testimony. The judge is the sole judge of the law. So if I've got a liberal judge and that judge is doing everything in his power or her power to hamstring me, the thing that saves me at the end of the day in more than 9 out of 10 trials is I've got a jury that's deciding the facts of the case, not the judge. And I've got a jury determine the credibility of the witnesses that testify and the way to give their testimony.
So for a bench trial, you would have a different approach.
When you're going to counties that you're unfamiliar with, or you have concern about that judge, you always select trial by jury. You have that right. And as long as you pay, you know, you ask for a jury trial and you pay that jury fee timely, it can't be taken away from you. So when I'm out in all these other locations and I'm trying cases against all these liberal judges, I'm talking about juries in San Antonio and juries in Houston. 99% of the time, it astounds me the jury sees through everything and does the right thing. And the right result occurs. And that's my saving grace as a trial attorney. When I'm going to these places where the judge makes it extremely difficult or impossible for me to get what I think should be a fair trial. Thank God for the jury.
Thank you.
Sounds good. Why don't we go ahead and close it up, and You're welcome to use up to 5 minutes on your.
You know, the weird thing was when John Works told me I had 5 minutes for opening and 5 minutes for closing, I asked him, I said, surely people don't take all 5 minutes.
But you did.
But I did. I mean, I literally saw the last 2 in 1 second click off on my
I
opening.
think it's the genes of an attorney.
It is.
Paid to talk.
You know, the
Just like
bad
a
thing
preacher.
about being a trial attorney is that we have the gift of gab, okay? We've got to be able to shoot from the hip, talk from the hip, face whatever situation is thrown at us at any given time. And that's what makes a good trial attorney, is to be able to handle that. I don't want to rehash what I've already said. All I would tell you is that, you know, I've got, and I'm just starting, but I've got cards with my contact information on it. I've got push cards that tell you why I'm running, that have contact information on it. And I'd ask you to go to, you know, Goleman, Golemon. You gotta make sure you spell it right. Golemon 2020 at gmail.com. That's my campaign email address. Email me. I'll answer any question you have. I even give you my phone number, my personal cell number, 936-520-2685. 936-520-2685. You call me. I've got a campaign website, golemanforjudge.com. Go to that, check me out, look me up. Call attorneys that you know and ask them about me. I mean, I've been in this county 31 years. I can't tell you how long I've been on the Montgomery County Bar Association Board of Directors. I'm a past president. Everybody knows me. Everybody knows my involvement in the county. Everybody knows my wife, Doris Goleman, and her involvement in this county. You talk to those people, they're going to tell you what type of people we are and how we're involved in what we do for Montgomery County. But I want you to check me out and see how I'm qualified to be your Chief Justice of the 9th District Court of Appeals. I can't tell you or emphasize to you enough for this particular position how important extensive trial experience is to be qualified. And I have that extensive trial experience. And like I said early on, I have nothing bad to say about my 4 opponents. I know them. I've known some of them for quite a while. They're fine people. They're nice people. They're friendly people. We're cordial and polite and complimentary to each other on the campaign trail. But you need to find out if they're qualified to be judge of this bench. And what you're going to find out when you look into those 4 individuals and you combine all of their trial experience together, they don't come anywhere close to my 300 plus jury trials. I'm not trying to brag, but I feel like I'm the only one of the 5 candidates that's qualified to fill this position. And I'd ask you to look into me, research me, check me out, make an informed decision of what candidate is the most qualified. And when you do that, I ask for your vote, I ask for your support, I ask for your voice, I ask you to spread the word to elect Scott Goleman as Chief Justice of the 9th District Court of Appeals. I want to thank you. I want to thank you for your support and your vote. God bless the United States. God bless Texas. God bless Montgomery County. And thank you.
Thank you very much. Good luck in your campaign.
Thank you.